Welcome to Oil and Gas. Today we'll talk about an issue that we previewed last time, which is what happens when there are a number of people that each own a fractional share of the mineral interest. How do you develop that property? Who has to sign a lease? How do you share between those different parties? So we'll begin to talk about co-tenants and shared rights. Now, here are some of the issues that arise. Who has to sign to give you a valid lease? What happens if one party won't sign? How are the lease benefits divided? And what rights do those shared owners possess against each other? Finally, what duties do shared rights owners owe to each other? So we'll start out with a case that's a little bit of an anomaly. It's this Law versus Heck Oil Company, and it's an old West Virginia case from 1928 on page 486 of your book. In that case, the defendant owns an oil and gas lease that covers 130 acres. The plaintiff owns just 1/768th of the minerals and challenges the lease because he didn't sign it. So, as we discussed, over time, if oil and gas interests are passed through inheritance and are shared equally, and if you had kind of that spreading family tree, you can get tiny shares of minerals, or somebody could have sold the tiny share of minerals. So you get these tiny fractional interests, and the plaintiff here has one, owns just 1/768th of the lease. Court says this owner who owns just 1/768th can stop development. The oil and gas company, the defendant, just wanted to pay him money and said, look, I'll give you your share, but I'm going to go ahead and operate because I have 767 of 768th of this property leased, and so I'll give you some money. The court says, well, wait a second, that would turn real property into money. The whole point of having real property is that if you have a house and your neighbor says, I want to buy it, even if they're offering you a great price for it, you can say no. Even if the King of England shows up and says, I'll pay you 3 times what your house is worth, you can say no. And so since the point of property is to have that control over it, this single mineral interest owner can enjoin development. Otherwise, you're forcing a trade of real property for cash. Now, note that there is an exception to this rule that the book notes to protect against drainage. So the plaintiff here was able to hold up production until there is some risk that the oil and gas would be produced by a neighboring property. Then we might say, well, look, you have to drill at that point, just compensate that fractional owner. Also, what if this had all come up after the company had actually already drilled? Well, then, what is the plaintiff going to get? They're just going to get money, which is all the oil and gas company wanted to give them anyway. So usually this fractional interest holder will not be able to hold this up unless they challenge before drilling, as is the case here. Okay. Now, in most states, you don't necessarily need that. You don't need unanimity to start drilling. So let's look at this Oklahoma case, Prairie Oil and Gas versus Allen from 1924. In that case, Allen bought the surface and 1/10 of the minerals. So he just bought 1/10 of the minerals, but the land company reserved 9/10, 90% of the minerals. The land company leased to this oil and gas company, Prairie Oil and Gas, and it completed 3 wells. Allen says, well, I never consented to that, so I should get trespass damages. So Allen said, look, I'm not saying go dig up your wells, but I want 1/10 of the oil produced with no deductions for production costs. Okay, how much is that? Is that a lot or a little? Well, think about what Allen would have gotten if he had leased his mineral interest. If he had leased his mineral interest, what royalty does a typical lease provide for? 1/8. So normally the whole, for if you have 100% of the property, you get 1/8. The oil and gas company needs 7/8 to compensate it for the expenses it is taking on and the risk it's taking on. So if you have 1/10 of a mineral interest, you get the 1/8 of your 1/10 share. So you're going to get 1/80th. Remember, and as we'll do some more fractions later, but remember when you want to say, a fraction of a fraction, just multiply those numerators, multiply those denominators. 1 times 1 is 1. 1/8 times 10 is 80. So we have 1/80th. Alan says, well, wait a second. No, this is just a trespass on my land. You had no right to operate on this property that I own 10% of, because like in that Law versus Heck case, you should have had a approval from all the owners. And so as a result, I shouldn't get 1/80th. I should get 1/10. Court says, no. And this is the majority rule. Tenant in common has the right to develop without the consent of the other co-tenant. But you do have to compensate that co-tenant who's non-consenting. What you pay is the market value of the oil less the reasonable and necessary expense of developing, extracting, and marketing the same. Okay, so what does that mean that Alan should get? It's not 1/80th. In the long run, it would probably work out to be more than 1/80th. Because remember, oil and gas companies, they spend money on a lot of wells. And the reason they ask for 7/8 in return is because not all those wells hit. When they actually find a paying well that's giving them money, their profit, they might make a significant profit on that. So maybe, they only need half of the oil to pay their costs back, right? And so in this case, if they only need half of the oil to pay their costs back and the other half is pure profit, that means that Alan's going to end up with half of 1/10. So this is a really good well, and half of the oil ends up being profit to the company. Then Alan is going to get half of it. He'll get about, maybe 1/20th, okay? Now, there are still some disadvantages. Some wells never become profitable. They produce oil, and so the landowner gets a royalty. It gets his or her 1/8 share, but the oil and gas well never pays off the cost of drilling it. So in that situation, what would Alan get? Alan would get 0. And Alan would also not get as much money right away, because before it started paying him, the oil and gas company would be allowed to recover its net reasonable and necessary expenses of developing, extracting, and marketing the oil. So the company would still be able to recover those costs. Still, if you are playing the odds, this is much better than a 1/8 royalty, because effectively you're getting all the profit from your share of the oil. So if you are a non-consenting tenant in common, normal rule is you get all the profit from your half. You don't get all that oil, because some of the oil needs to be used to pay back the cost, but you get all the profit. And think about, that's kind of a great situation. So let's imagine that instead we have, 2 parties, A and B, and they each own an undivided 50% of the minerals. We say an undivided because we mean it's not like, if it's a 40-acre plot, it's not like each of them owns specifically 20 acres or the other 20 acres. It's undivided because all of them own 50% of all 40 acres. Okay, so what happens when the oil and gas company wants to develop this property? It goes to A and it gets a normal 1/8 lease. That means that A is going to get 1/16 of all production on the property. Okay, because A is going to get his or her 1/8 royalty on half of the production, because A owns half of those minerals, but B refuses to sign a lease, and B gets all the profit for his 50% of the minerals. Okay? So notice from the oil and gas company's perspective, this is a big problem because there's no way he can profit off of, the oil and gas company can profit off of B's share because any profit is going straight to B. The only profit the oil and gas company can make is on the 7/8 of A's share that it gets to keep. So even though in most states a co-tenant, somebody who owns an undivided share, in theory has the power to lease his or her minerals, even if they had a small share, even if Alan here with that 1/10 share tried to lease the minerals. You'll remember that Colorado County case, the McSwine case, where the county tried to lease its 2.5% share of the minerals. That's in theory just fine. You can lease your tiny share. The problem is oil and gas companies won't want to do that unless they know they can also get a lease with the bigger party, because they know that, in this case where it's a half and half split, they'll get no profit. They have to turn over all profits to B. So they have all downside, because if they lose money on this, they don't get to recover any of that from B. Their best case on the 50% of the minerals that belongs to B is that they pay back their cost of development, and from there on, all the money goes to B. So B gets to keep all of that. The only part that the oil company gets to keep of its profits is from A, because A agreed to a 1/8 royalty on its 1/2 share. So the oil company gets to keep the other 7/8 of that 1/2 share. All right, so co-tenants. They are owners of undivided interest. They're tenants in common, it's also called. And majority rule, it's rule in Texas, rule in Oklahoma, any co-tenant may lease or develop, but you have to have that accounting. The accounting is when you give them their share of oil and gas production minus the cost of development. It's basically all the profit in their fraction of the mineral interest. Now, that minority rule, which you saw expressed in West Virginia, is that all co-tenants have to agree. There are sort of less extreme versions of that in Louisiana, where you have to have 80% agreement, and in Illinois and Michigan, where you need 50% agreement. So what happens when co-tenants use different lessees? They don't have to lease to the same oil and gas company. They can lease to different lessees, different oil and gas companies. So basically what happens then is you have a joint operating agreement. We talked about that a little bit in the last video. A joint operating agreement allows different oil and gas companies with leasehold interests to work together to develop a single property. One oil and gas company will take the lead as an operator. These joint operating agreements are a huge area of legal oil and gas practice litigation, but it's beyond the scope of this course. It's in the oil and gas contracts course, that advanced oil and gas course. And you can actually see, that's a great course to take because you just get to use this book because that's the last chapters in this book. We also, in international practice, joint operating agreements are common. And I talk about this in my international petroleum transactions and energy development course. But it's basically beyond the scope of this class, except to say that oil and gas companies have to work together. When they do that, you will often have split stream gas sales, which means all those different companies that have leases on a single property, one company is operating it, but then they're sharing in the gas that comes from that well. And so each of those companies have to find somebody to sell that gas to. Now in Texas, that means that whoever you lease to, they're responsible for selling your gas. And if they make a good deal, that means you'll get more on your gas. They make a bad deal, it's a bad deal for them too, but you'll get less on your gas. In Oklahoma, instead, you say, look, from the same well, everybody should get the same price. So we're just going to get a weighted average of what the average price is from these different lessees, different oil and gas companies, finding buyers for the gas that they're producing. All right, sometimes this problem of common ownership of a resource is met with a community lease, where the different parties that each own part of the minerals come together and form a community lease. So that can cover either neighboring tracts where they're owned separately, or it can cover, it could be a community lease from the members in common, those tenants in common that own a single piece of land. Like that example I gave you where A and B own 50% of land, that can give you they could sign a community lease. Now, the community lease is just a little bit simpler because rather than signing separate agreements, you just sign one agreement together. Now, there are some interesting ramifications of a community lease, some consequences. So, for instance, in Texas, there's a strong presumption that when you sign a community lease, you're intending to pool your interest. And that's important when you have neighboring properties, because if there's production on any one of those properties, the assumption is if you signed one lease altogether, you are intending to share all the oil regardless of where it was produced, whose property it was produced on. In Oklahoma, there's also an inference that you are intending to pool, but that can be rebuttable. And in New Mexico, there's no inference at all. So we'll talk about some of the consequences of this. And to do that, we get to do some real good fractions. Page 500, this community lease problem. So what I want you to see is, just like in that last problem I gave you, imagine A and B, Adams and Brown, each own an undivided 50% interest in Tract 1. Tract 1 has 100 acres. They join a community lease that has just a standard 1/8 royalty and standard pooling clause with Castle, who owns Tract 2, which is 200 acres. So imagine that we have A and B. Remember, they have an undivided 50%. Each of them owns half of this tract. And then you have Castle, C, that owns all of this 200-acre tract. And what I want you to then imagine is that, so there's a community lease with all three of these parties. As I said, it can be between neighboring landowners, and it can be between tenants in common who have an undivided interest. So A and B are neighbors of C, and but A and B, with respect to each other, are tenants in common. Now, imagine that the lessee, the oil and gas company that they've signed this community lease with, pools just 20 acres from Castle's tract with 20 acres from just another neighbor. Who knows who it is? It pools that land. How much oil does every party get? Okay. So first thing, remember the neighbor is not included in this community lease. So how much does the neighbor get of the oil that comes from this well on this pooled tract right here? The neighbor is going to get, let's assume the neighbor, we don't know anything about the lease, but let's assume that like the one community lease, it's a standard lease, and the neighbor has negotiated for a 1/8 royalty. So the neighbor gets a 1/8 royalty on production on his land, but how much of this unit is on the neighbor's land? Just half, right? 20 out of 40 acres, because the lessee pooled 20 acres from Castle's and 20 acres from the neighbor. So the neighbor gets 1/2 of this tract. So the neighbor gets his 1/2 of 1/8, right? You would normally get a 1/8 royalty if it was all on his land, but only half of it is on his land. So overall, multiply the top, multiply the bottom. 1/2 of 1/8 is 1/16 for the neighbor. Okay. So what does that leave for A, B, and C? Well, A, B, and C, again, imagine this is Texas. When they sign that community lease, there's a strong presumption that they pooled their land. So when they pooled their land, now it doesn't matter where the well is physically between the three of them. So you might think, oh, Castle should get the other half because half of the pooled unit is on Castle's land. But remember, Castle pooled his land with Adams and Brown when he signed this community lease. And so as a result, Adams, Brown, and Castle are all going to share in the production that takes place within their lease. Okay, so how much are they going to share all together? Well, it's going to be the other 16th, right? Because they together, A, B, and C all together, have half of that unit. The landowner share is 1/8, so they get 1/2 of 1/8, it's 1/16. Okay. But how is that going to be shared between A, B, and C? Well, let's look at this. When you pool, and A, B, and C have pooled, how do you share revenue under that pooled lease? It's on the basis of acreage. And C has 2/3 of the acreage in that pooled lease, right? Because there's 300 acres, 100 for Adams and Brown and 200 for Castle. So C is going to get 2/3 of that 1/2 of 1/8. Okay? Because C has 2/3 of the land, owns those 200 mineral acres. And so C is going to end up with multiply across the top, multiply across the bottom. We have 2/48. Could reduce that fraction. That's 1/24. Okay? Now, one thing I should tell you about fractions as you're doing them in this class, on the exam, I will not require you to reduce fractions. 2/48 is totally fine. 1/24 is totally fine. If you want to, you can just say 2/3 of 1/2 of 1/8. That's fine too. Just, you don't need to reduce fractions. You don't need to do the fraction math, but it can be helpful in thinking about these problems to make sure it all adds up, etc. So you might remind yourself of how to do those fractions. And I can promise you, the examples I give you will be far easier than the examples that you will encounter in real life as an oil and gas attorney. I'm not going to give you those 1/768 like you see in the problems in the book. Okay, so finally, what do A and B get? Well, they together have those 100 acres out of the 300 acres in the community lease. So each of them would just get 1/3 of that 1/2 of 1/8. But each of them only own half of that 100 acres. Sometimes we would say they own 50 mineral acres, right? So sometimes we say, they have a 50% ownership in 100 acres. That's like owning 50 mineral acres, okay? So basically for each of those parties, you're going to have, and I'm going to write it up by their names up on top here. You're going to have, they own 1/2 of that 1/3 that together they own 100 of 300 acres in the lease of that 1/2 that lease shares in the 40-acre pooled unit of 1/8 the landowner royalty. Okay, multiply across the bottom, 2 times 3 times 2 times 8. So it's 12 times 8, which is 1/96. All right, so let's check it out. Neighbor gets 1/2 of 1/8, that's 1/16. Castle gets 2/3, his landowning in the lease of 1/2 of 1/8. As we determined, that's 1/24. And Brown gets 1/2 of 1/3 of 1/2 of 1/8, and we determined that's 1/96. So they each get 1/96. You may want to try going through that again by yourself. Print it out, go through it, and just get used to allocating on the basis of acreage and ownership, the landowner share of production from a well. All right. Now we need to talk a little bit about partition. We're going to do that through Mosley versus Harrell. This is a 1943 case from Texas. In this case, there's a suit for partition of the mineral interest in a very small 1-acre tract. Court says, statute allows you to partition without concern about equity. So it's just a right to have the property partitioned, but equity determines how it's partitioned. Now, often at common law, you partition in kind. So if you had 100 cows, you would give 50 to each owner. And the benefit of that is they don't have to consider how to manage them together anymore. They can each just have their half of the herd. The same thing would make a lot of sense if you had, 100 acres that were really only useful for growing corn, and they were all equally useful. You take those 50 acres, you take those 50 acres. But there's this rule that it can't diminish the total value of the partitioned property. And here, that means, and with oil and gas generally, that means you're just going to have to sell the interest because only one well could be drilled. You can't really partition it. So the court says you have to sell the property. And we'll see that this is consistent with the general rules for partition. So generally, the co-tenant has a right to division of undivided interest. We see all these problems that result when you have an undivided interest in a property and one party won't lease, the other party will, et cetera, et cetera. So generally, there's a right to division. So you can demand it whenever you have joint ownership of a possessory interest in an estate of equal dignity, like you both have the fee, you don't one, it wouldn't work if one had a life estate and one had fee or otherwise, that extends throughout the land. So it's an undivided interest in the land. You can ask for partition. In-kind partition, as we said, if you had cows or just agricultural land would be preferred. But if there are minerals, then you're going to just sell the property. Okay, that by sale partition is what you're stuck with, the default. Now note that that might undercompensate you for all the reasons we've described in class, where you're really better off often leasing your property rather than selling your minerals. Partition isn't a great option because you may get less money overall. So this is one reason why a lot of times, even as much of a pain as it is to deal with co-tenants, a lot of times they will try to find a way to lease the property because the idea is maybe you'll get more money that way because of the way it shares risk between the lessor and the lessee, leading to more compensation for the lessor.